Hello, my name is Michael Tesoro, and I've prepared this video case note on the recent case of Qualcomm Inc. and the European Commission. Bit of background about myself: I'm a competition and consumer lawyer, and I've been running my own practice, Tesoro Consulting, for the last 14 years. That time I helped a number of companies with competition and consumer law matters. Prior to that, I worked at the ACCC for 15 years in a variety of roles, including in enforcement and mergers and asset sales. Now, that on the presentation, I'll start with an introduction, then look at the EC's decision, then spend quite a bit of time looking at the General Court decision of 15 June 2022, and then finish with some commentary. Now, Qualcomm is a US company which is a leader in the field of cellular and wireless technologies. In particular, it makes chipsets and software for use in a variety of different types of technology, primarily mobile phones, tablets, and laptops. And it supplies these chipsets to a large number of very big companies, including Apple, LG, Samsung. And this particular case relates to an agreement that it entered into with Apple. Now, the EC decision was that it alleged that Qualcomm had abused its dominant position by entering into an incentive agreement with Apple, whereby Apple would agree to buy all of its LTE chipsets from Qualcomm for its iPhones and its iPads. And the EC was concerned that these payments were exclusivity payments, which had the capacity of creating an anti-competitive effect, namely by foreclosing competitors from winning the business of Apple. And Qualcomm were not able to satisfy the EC that the payments could be justified in some other way, namely in terms of efficiency or consumer benefit. As a consequence, the EC imposed a fine of 997 million euros or $1.46 billion Australian, so it's a very large penalty. The EC defined the market as a global market for the supply of LTE chipsets, and it's interesting that they excluded two different types of product from the relevant market. Firstly, they excluded what they called captive production. So for companies that made their own chipsets internally and used them in their own devices, they were considered to be outside the market as not exercising any competitive constraint on Qualcomm. It also excluded another type of chipset, namely the GSM standard and chipsets compatible with the UMTS standard. So they were excluded from the relevant market. So the market was limited to LTE chipsets. The EC concluded that Qualcomm had abused its dominant position in the relevant LTE global market in the period from 2011 to 2016, after which time things changed in the market and the dominant position was lost. But during that period, it had a dominant position according to EC. And this dominant position arose from large market shares, but also from a number of barriers to entry, primarily from a wide range of patents, which gave Qualcomm its technological advantage over its competitors. Also, the EC concluded that there was effectively no countervailing power in the market. So Qualcomm's very large customers did not have the capacity to adversely affect Qualcomm's dominant position by either moving sales away from Qualcomm to a competitor or alternatively backward vertically integrating into the manufacture of chipsets. Now, Qualcomm appealed the decision and sought, obviously, the annulment of the decision that it had abused its dominant position in the relevant market, but also an annulment of the fine that was imposed. Now, Qualcomm appealed on a wide range of grounds, and I think I'll cut to the chase here and say that Qualcomm was successful and had the decision set aside. And the approach that the General Court took was a pragmatic approach, decided to look at a few of the grounds which effectively meant that Qualcomm would win and therefore didn't need to discuss the other grounds. And there's 7 grounds there, but most of these grounds have a number of sub-grounds. So as you can imagine, it extrapolates out to quite a large number of separate grounds. So what the General Court did was focus in on ground 1, manifest procedural errors, and also ground 3, manifest errors of law and of assessment as regard to anti-competitive effects. And Qualcomm won on those 2 grounds, so there was no need to consider the rest of the grounds. So 2 related to the EC's approach to efficiencies, 4 related to its approach to market definition, 5 related to the duration of the alleged infringement, 6 related to the way the EC approached its guidelines in setting the fine, and finally 7 was a jurisdictional argument. So all those other grounds didn't need to be considered. Now, as I said, it focused in on two grounds, but under each of these grounds there was a number of sub-grounds. So again, it took a pragmatic approach and decided to consider some but not all of these sub-grounds. Looking at ground 1, the manifest procedural errors, that had 4 parts to it. And in this particular case, the General Court looked at 1 and 3. So it looked at whether the rights of defence of Qualcomm had been adversely infringed or impeded by the EC, and also whether the EC had infringed Qualcomm's rights of defence by failing to disclose evidence that was relevant to its defence. I think there's a strong implication that had the General Court looked at 2 and 4 in this sub-grounds, I think Qualcomm would have been successful in those grounds as well. Now, ground 1, sub-ground 1, was relating to Qualcomm being deprived the opportunity to comment, and the key issue here was that the EC issued a statement of objections, which is like a preliminary decision to Qualcomm, and in that decision they had defined the market as including both UMTS chipsets and LTE chipsets in the same market. So they alleged that there was an abuse by Qualcomm in that broader market. But then the contested decision comes out and the market has been narrowed to solely LTE chipsets. So that's not a very good way of operating. Realistically, if a regulator is going to make such a major change between its statement of objections and its contested decision in terms of market definition, it really should have advised the relevant party of that change of mind prior to making the contested decision and giving the party an opportunity to comment. But the specific complaint raised in this case related to a document prepared by Qualcomm, which was called the critical margin analysis. And it had prepared this in response to the statement of objection. So obviously the report prepared by Qualcomm looked at the broader market of LTE chipsets and the UMTS chipsets and looked to see what impact the merger would have, the conduct would have in relation to that broader market. Now, the CMA is explained as follows in this slide: an economic analysis which seeks to demonstrate that a hypothetical competitor, which is as efficient as Qualcomm, could have competed with Qualcomm to supply, as you can see there, both LTE and UMTS chipsets to Apple, and that the price that it could have offered would have been able to offset not only a competitive price to Apple, but also the other costs associated with the agreement, which was the incentive payments. So they did an analysis which proved that a hypothetical as efficient competitor could have done that, which would have undermined the view that there was anti-competitive effect. However, when the EC changed its market definition, this report was not relevant at all. However, the EC did not give Qualcomm an opportunity to revise their report. Now, as you can see there, the General Court said that the Commission basically relied on this critical margin analysis, which was no longer relevant to the abuse which it found. This report was relevant to the statement of objection abuse, which involved both markets, but it was no longer relevant to a market limited to LTE chipsets. And by effectively proceeding with its decision, the EC had effectively infringed Qualcomm's right of defence. It should have given Qualcomm an opportunity to revise its critical margin analysis and to submit that to the EC before it reached its contested decision. Now, moving on to the next one, this is ground 1, subground 3, which is a failure to disclose evidence. And what you have here is a long description in the judgment of various interviews with competitors, with anonymous third parties, conference calls, other meetings, which were not properly recorded or not recorded at all. And in the European system, being an administrative system, all this evidence that the regulator gathers during its investigation has to be provided to the company under investigation for their review and comment. And there's actually a data room which is made available to the company under investigation. They can come, the lawyers for the company can come in and look at all the material, take notes, and make a response. So what the General Court found was that the EC's having lots of meetings with different parties, including competitors who are allegedly foreclosed by Qualcomm's conduct, anonymous third parties, and it's not making either proper records of these meetings or any meetings, any notes at all. So as you can imagine, Qualcomm is being denied the opportunity to respond to allegations and claims made against it. And there you see paragraph 2 there, Qualcomm received no information on the very existence of a number of interviews until after the contested decision had been adopted. So it's a very unusual way for the EC to approach this matter to really prevent Qualcomm from having access to so much relevant information about the case and preparing very, very short notes with really no detail whatsoever, or not advising Qualcomm at all that certain meetings have occurred. So as you can see there's a clear infringement of Qualcomm's rights of defence. So at this stage, the decision's effectively set aside, but the General Court decides to look at some of the other grounds, which aren't procedural grounds. They're more really substantive grounds as to the way the assessment of anti-competitive effects has been worked out. Now, ground 3 again had 3 subparts, and it relates to manifest errors of law and of assessment as regard to anti-competitive effects. And even though they're stated as being 3 different grounds, they're very closely related. The first one was that the EC did not apply the correct legal standard. The second, that they did not apply the case law on pricing practices. And thirdly, that the agreements were not capable of having potential anti-competitive effects. Now, a really important bit of background here, and it is pretty staggering really when you read this, but it was established in the case that at the relevant time, Apple had no technical alternative to Qualcomm's LTE chipsets for its iPhones and therefore could not switch to other suppliers. So the whole argument based on foreclosure really can't be successful if Apple has no alternative supplier. And it's very key bit of information is that during the relevant period, 90% of Apple sales that use LTE devices. So effectively for iPhones, there was no technical alternative to LTE chipsets, so that was locked in. The iPhone demand for LTE chipsets was locked into Qualcomm. iPads, which is the other product which required LTE devices and chipsets, only represented 10% of Apple sales. So as you see there, the conclusion by the General Court, for a very large part of Apple's requirements for LTE chipsets for devices, Apple had no technical alternative to Qualcomm's LTE chipsets and therefore could not switch to competing suppliers. Now, that is a staggering conclusion to be aware of, given the decision which was reached by the EC. And the General Court says, well, in the light of that, the Commission could not have reached the conclusion that the payments had reduced Apple's incentive to switch to a different supplier of LTE chipsets for all of its demand for iPhones and iPads, because simply put, it couldn't move the iPhone LTE chipset demand to any other competitor anyway. And then the obvious conclusion that EC could not have legitimately concluded that the payments that were being made by Apple to Qualcomm reduced Apple's incentives to switch to an applicant for all of its requirements, including iPhones and iPads, because it simply was unable to move the iPhone LTE demand to anybody else but Qualcomm. Now, there was some sort of strange arguments made by the EC about a clerical error and all the rest of it, but regardless of what error was made, if 90% of Apple's demand for LTE chipsets is locked into Qualcomm, there cannot be any foreclosure argument. Simple as that. The specific grounds, manifest error of law and breach of principles of legal certainty in failing to apply the correct legal standard. Obviously, it follows that the decision of actual anti-competitive effects of the payments cannot be made out. And this is a failure to ensure consistency between the evidence and the findings made. So the findings made do not follow on from the evidence before the EC. The next ground was a failure to apply the case law and pricing practices. Here, the General Court found that the EC did not provide any analysis which was able to support its finding that the payments had actually reduced Apple's incentives to switch, because, as stated before, most of that demand was locked into Qualcomm. Third ground, manifest errors in relation to the finding that the agreement was capable of having anti-competitive effect. Again, it stands to reason that this could not have followed on from the fact that Apple could only use Qualcomm for its iPhone LTE chipset requirements. And in this particular part of the case, the General Court is looking at a number of other bits of evidence which the EC sort of desperately trying to rely on to justify its decision, and it just doesn't stack up, fundamentally doesn't stack up. So it all flows from that simple fact that there was a technical obstacle to Apple moving its iPhone LTE chip requirements to anybody else. So it follows from the decision that has been reached earlier that there's no need for the General Court to go through all those other grounds of appeal, because the Qualcomm has succeeded on two major grounds. Firstly, the examination of the capability of the payments concerned to have anti-competitive effects is founded on an analysis which was not carried out in the light of relevant factual circumstances. So they've found an anti-competitive foreclosure effect in circumstances where the vast majority of demand of Apple was captive, was locked into Qualcomm. Second, the examination of the actual effects of the payment concerned is founded on an analysis which does not stack up. So really the whole conclusion of anti-competitive effects reached by the EC was wrong and could not be substantiated and sustained. As a consequence, the General Court decided that the contested decision, based on just a few of the appeal grounds, had to be set aside. So just a bit of commentary here. It's quite staggering, the mistakes made by the EC in this case. Like, the procedural errors are pretty inexcusable. The EC knows the rules that apply in relation to taking notes of meetings and other communications with market participants, particularly competitors who are alleging that they're going to be foreclosed by the conduct of the applicant, in this case Qualcomm, and not to take records of those meetings or to take defective records of meetings is inexcusable. To not tell Qualcomm of the existence of some of these meetings is also inexcusable. And that ground alone, the decision was going to be at least remitted back to the EC and had to be remade. But then the following errors in relation to the actual analysis of the conduct and the conclusion that it foreclosed competition in a market that was not largely contestable is again mind-boggling. How the EC could have concluded that the payments were foreclosing competitors for iPhones and iPads when it well knew that the iPhone demand at the relevant time was not contestable. Nobody had the technical ability to meet Apple's requirements. And if the EC had based its decision solely on iPads, it would have been hard to sustain that the conduct had significant anti-competitive effects, given that iPads is sort of a old technology which is reducing in even at that time reducing in popularity and only constitute 10% of Apple sales. So standing alone on the basis of demand for iPads would not have been enough to sustain the decision. So it's quite hard to understand how the EC got it so wrong in so many respects. And I think it's fair to say that had a number of the other issues being looked at by the General Court, they probably would have lost a number of those. Like even the market definition argument seems a bit shaky, but that wasn't needed to be looked at by the General Court. And this is a bit about the EC has had a bit of a bad record in recent times. Like clearly the Google shopping case has been affirmed by the General Court, but we've got the Google Android case coming up, and some other AdTech type cases. The Intel case was overturned not long ago by the General Court. And I think there's a real importance for the EC to really drill down on the way it's doing the cases, particularly the procedural elements, but the fundamental theories of harm have to be worked out on the basis of all the evidence that is available. And the other thing that's interesting here is the transparency. Like being an administrative agency that can impose fines, the EC has a lot of front end transparency obligations in terms of making interviews with complainants and competitors available to the applicant at an early stage and making a data room available. But in Australia, it's a very similar scenario. The ACCC doesn't have an administrative power to fine companies, but it has to go to court to prove its cases. And so it's really important that all relevant material that is going to be relied upon by the regulator is able to be obtained in an admissible form that is able to be put to a court, that can't hide behind a confidential information being provided in litigation. You have to be able to put witnesses in witness boxes. And so the ACCC has to be mindful of the need to ensure that all the steps it takes when it does decide to take on one of these large companies in some litigation have been done appropriately and correctly. And I think in many respects the ACCC has been able to do that in much of its litigation. It ensures that it gets the evidence it needs and puts it forward in contested litigation. So it's an interesting case. I think it's a big embarrassment for the EC, and there's a real pressure on them to improve the way they're undertaking their cases going forward, particularly any future cases against big digital platforms who have the resources to contest these cases very aggressively. That's all I had. If you have any questions about this presentation, please feel free to drop me an email or give me a call. Bye bye.